Hello and welcome to Courts Today by Live Law. Let us get to today's top legal updates. The Calcutta High Court has reserved order on the admissibility of states and CBI's appeal demanding death sentence for Arjikar Convict. A Supreme Court bench today delivered a split verdict on the plea of a Christian man to bury his father at his native village. Eventually, the bench directed for burial at a place in another village. The Supreme Court has granted bail to Telangana police officer accused of phone-tapping bureaucrats and judges. In a plea seeking admission for Rohingya children in local schools, the Supreme Court has asked the petitioner to file an affidavit informing where the Rohingya families live. In the Anna University sexual assault case, the Supreme Court has stayed Madras High Court's directions against Tamil Nadu police over an FIR leak. In a matter today, the Supreme Court remarked that whenever there is a protest, Section 144 CrPC order is issued, which sends a wrong signal. The Supreme Court has appointed an independent observer to supervise Chandigarh mayoral elections on 30th January. And the Allahabad High Court has questioned credentials of a man who moved a PIL to protect the 17th century Agra's Hammam. This is your host Urvashi Chauhan with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Make sure to watch this video till the end and do not forget to like, share and subscribe to our channel because your support means the world to us. The Calcutta High Court has reserved its order on the admissibility of appeals filed by the state of West Bengal and CBI against the life sentence awarded to Sanjay Roy, who was convicted of rape and murder of the trainee doctor at Arjikar Medical College and Hospital. Both authorities have demanded a death sentence for the convict after the Sessions Court held that the crime did not fall into rarest of the rare category and denied the death penalty. The CBI has opposed the state's appeal on the ground that it was not admissible since the probe was carried out by a central agency and hence only the central government was authorized to sanction an appeal against the order. Advocate General for the state submitted that as per sections 377 and 378 of CrPC, though the central government could appeal against orders in cases which were investigated by central agencies, the presence of the word also in subsection 1 made it clear that the state was also empowered to maintain an appeal in such cases. It was submitted that in this case, the appeal was for enhancement of sentence and that the case had been initially investigated by the state police and the probe was thereafter transferred to the CBI by the High Court. Since the prosecution was in the name of the state and had been started by the state would also be competent to appeal. ASG SV Raju, appearing for the CBI, submitted that the case had been transferred to the CBI on 13th August last year and that post that date, all the materials and records had been handed over to CBI with nothing being left with the state. It was submitted that even the entire prosecution was carried out by CBI and its appointed prosecutor and the state chose not to participate in the trial either. Finally, it was submitted that in such cases, due to Section 418 of the BNSS, the state could not maintain an appeal against orders in cases which were investigated by central agencies and that the only remedy available to the state would be to file a revision plea. Upon hearing the arguments, the bench questioned as to why two Article 12 authorities, who were demanding similar sentences, had approached the court to adjudicate on whose appeal should be admitted. Taking all materials on record, the bench of Justices Debangsu Basak and Mohammad Shabar Rashidi closed the hearing and reserved the judgment. Stay tuned for the verdict. In the next update, the Supreme Court bench of Justices B.V. Nagratna and Satish Chandra Sharma delivered a split verdict on the plea of a Christian man from Chhattisgarh to bury the dead body of his father, a pastor, either in the burial ground of their native village Chhindwara or in their private agricultural land. His father passed away on 7 January and since then his dead body has been lying in the mortuary. As per the state, individuals who have renounced community traditions or converted to Christianity are not permitted to be buried in the village graveyard. The state also opposed the petitioner's alternate request to bury his father on private land, stating that burials can only occur at designated sites. The petitioner argued that the state's own affidavit shows his relatives were buried in the village graveyard. He highlighted cases of Christian tribals being buried there and claimed this discrimination arose solely due to conversion. As per the verdict delivered today, while Justice B.V. Nagratna allowed the plea of the appellant to bury his father in his private property, Justice Satish Chandra Sharma held that the burial could be held only at the area designated for Christians, which is at Karkapal village, about 20 to 25 kilometers away from the appellant's native place. Justice Nagratna observed that it was a violation of Articles 14 and 15 of the Constitution to deny the appellant access to burial ground. She also observed that what could have been solved at the village level had been given a different color. The state's stand gave an impression that certain communities could be discriminated against. Such an attitude on the part of the village level and the higher levels betrays the glorious principles of secularism and fraternity she held. However, having regard to the fact that the dead body has been lying in the mortuary since 7 January, the bench refrained from referring the dispute to a larger bench. Instead, the bench chose to pass a consensual direction that the burial be held at the designated place for Christians. The Supreme Court has today granted bail to Mekala Tirupatana, a suspended police officer accused of phone tapping bureaucrats and High Court judges after 10 months of incarceration. Last year, the Telangana High Court had initiated suo motu proceedings into the illegal phone tapping operation said to have been conducted when the BRS government was in power. The High Court had taken up the matter following a news article published in the Deccan Chronicle, which claimed that apart from rival politicians, High Court judges had become the target of phone tapping scam. The issue came to light in December 2023 after Congress won the elections and came to power within the state of Telangana. High Court had taken up the matter, stating that the issue involved national security and not just infringement of the right to privacy. Senior advocate Siddharth Luthra for the state of Telangana vehemently opposed the bail plea, arguing that the bail at this stage would prejudice the trial as some crucial witnesses were yet to be examined. Whereas senior advocate Siddharth Dave for Mekala stated that the charge sheet has already been filed and the purpose of Section 167 will be defeated if the petitioner continues to be incarcerated. Luthra then contended that although a charge sheet has been filed, custody is needed for further investigation because the case involves data which was collected. He stated that data has been sought from Google because the petitioner and other officers involved have destroyed it. Luthra particularly prayed for 3 months for further investigation. But a bench of Justices B.V. Nagratna and Satish Chandra Sharma expressed reluctance to keep the petitioner in continued custody. The bench questioned the state's inaction over the past year, remarking that the petitioner had served for 59 years without a single allegation against him and questioned the purpose of his incarceration. The bench granted bail while stating that the trial court may set appropriate bail conditions. Though Luthra urged the court to clarify that the order should not benefit other co-accused, the court declined to include such a condition. Moving further, in a petition seeking admission for Rohingya refugee children in local schools, the Supreme Court today called on the petitioner and NGO to file an affidavit stating whether the Rohingya refugees are confined in makeshift camps or living in regular residential colonies. A bench of Justices Suryakant and N. Koteshwar Singh passed the order in a plea filed by Social Jurist, a civil rights group, challenging Delhi High Court's dismissal of a similar prayer on the basis that it is for the centre to take a call on the issue. The petitioner had filed a PIL before the Delhi High Court seeking directions to Delhi government and Municipal Corporation of Delhi to allow Rohingya refugee children to enroll in schools near their residences. The petitioner claimed that the children were being denied admission due to the lack of Aadhaar cards. The High Court noted that Rohingyas are foreigners who have not been officially or legally permitted entry into India. Consequently, it had disposed of the PIL and advised the petitioner to submit a representation to the Union Ministry of Home Affairs. During the hearing today before the top court, the counsel for the NGO argued that the plea was focused on ensuring education facilities for the vulnerable Rohingya refugee children. Justice Kant inquired about the living arrangements of the Rohingya families, pointing out that if the children are allowed to leave their camps for schooling, their guardians would naturally follow them. He also asked for details such as families' addresses and ration cards, emphasizing the need for clarity before issuing directions for admitting the children into schools. The petitioner's counsel responded that the families were living in regular residential colonies and not confined camps. Justice Kant then directed the petitioner to file an affidavit confirming this and listed the matter for a hearing in 2 weeks. And now an update on the Anna University sexual assault case. The Apex Court today stayed the Madras High Court's direction to Tamil Nadu Police to hold a departmental inquiry regarding leak of FIR in the sexual assault case of a second-year engineering student inside the Anna University campus in Chennai. A bench comprising Justice B.V. Nagratna and Justice Satish Chandra Sharma also stayed the adverse comments made by the High Court against the state police in relation to the FIR leak. In December, the High Court, while directing an SIT comprising women IPS officers to investigate the allegations, had observed that there were lapses on the part of the police and the university. The High Court also remarked that the details of the FIR, which contained personal details of the victim, had been leaked and this had to be viewed seriously and investigated. The High Court had said that FIR leak was a serious lapse on the part of the police which caused trauma for the victim and her family. It had directed the state to pay an interim compensation of 25 lakhs to the victim girl, which could be recovered from those who were responsible for the dereliction of duty and leaking the FIR. At the Supreme Court today, a bench of Justices B.V. Nagratna and Satish Chandra Sharma, while stating that the SIT shall continue its investigation, stayed the operation of 4 paragraphs of the High Court's judgment, which put responsibility for lapses on the police officers. Senior advocates Mukul Rohtagi and Siddharth Luthra for the state of Tamil Nadu clarified that the lapses could not be attributed to Police Commissioner because the FIR uploaded on the Crime and Criminal Tracking Network and Systems or CCTNS had blocked personal details. However, due to a technical glitch and because the system had to migrate from older criminal codes to newer ones, it resulted in the leakage of personal details. Rohtagi pointed out that the state wrote to CCTNS to block the details of the FIR and that FIR was filed against unknown persons for the leakage of details. Adding to this, Luthra informed that all links through which the FIR could be possibly downloaded are blocked and will continue to be blocked. Justice Nagratna stated that whatever may be the reasons, a secondary trauma was caused to the victim. But nevertheless, the court stayed the operation of the 4 paragraphs of the High Court's order. In another update, the Supreme Court today flagged the misuse of Section 144 of Code of Criminal Procedure or the corresponding Section 163 of BNSS, which empowers authorities to issue orders restricting public gatherings, movement or activities to prevent disturbances to public peace and safety. A bench comprising Justice Abhay S. Oak and Ujjal Bhuya was considering a petition filed by the state of Jharkhand challenging the Jharkhand High Court's order quashing cases against 28 BJP leaders in connection to a protest against the state government in the year 2023. The counsel for the state submitted that the accused had violated Section 144 CrPC order and led a violent demonstration leading to injuries to public servants, police officers and journalists. At this juncture, Justice Oak orally said that there is a tendency that because there is a protest, Section 144 CrPC order is issued, which sends a wrong signal. The High Court had quashed the cases, observing that there were no direct allegations that the accused indulged in stone pelting and broke police barricades. The Supreme Court bench today said that there was no ground made out to interfere with the High Court's judgment. In a plea filed by Chandigarh Mayor Kuldeep Kumar, the Supreme Court has today appointed an independent observer to supervise the Chandigarh mayoral elections scheduled for 30th January. The election proceedings shall take place in the physical presence of the observer. A bench of Justices Suryakant and N. Koteshwar Singh heard the matter and ordered the appointment following a no objection given by Solicitor General Tushar Mehta on behalf of the municipal corporation. The mayor from the Aam Aadmi Party had filed this case seeking conduct of elections by show of hands as well as appointment of an independent observer to supervise the elections, citing last year's fiasco, if you recall, when ballot papers were found to have been defaced by the presiding officer and election results had to be set aside. Last week, the court issued notice to the Union Territory Administration for limited purpose of appointment of an independent observer. Today, S.G. Mehta, appearing for Municipal Corporation, submitted that history may not repeat itself every time. Be that as it may, the court deems it fit to appoint an independent observer. The corporation had no objection. Accordingly, the court passed its order. And lastly, the Allahabad High Court today questioned the credentials of the petitioner who moved a PIL plea seeking protection of a heritage building, the 17th century hammam or a public bath in Agra, claiming that it is facing the potential danger of being demolished by illegal and unauthorized persons. The plea alleges that the hammam, built in Turkish style, was constructed during the reign of Jahangir in 1620 by Ali Vardi Khan. However, recently the site was claimed to be private property and certain people started demolishing the structure. At the last hearing, the petitioner argued that it is the duty of ASI to protect historical buildings from any unauthorized damage under the Ancient Monuments and Archaeological Sites and Remains Act. The court had directed the ASI and the Commissioner of Police Agra to ensure that no damage is caused to the structure. Today, a bench of Chief Justice Arun Bhansali and Justice Vikas Budhwar questioned whether the petitioner Chandrapal Singh Rana had any personal interest in the cause and also queried him regarding his profession. The question was posed as the bench noted that while the petitioner had claimed himself to be a fruit vendor at one place in his affidavit, at another place in the plea, he had merely mentioned that he was a respectable citizen. Thus, granting him time to bring his credentials on record, the court adjourned the hearing on the matter.